Darlene,
Yeah.
how long did it take you to light all those
Are we
lanterns?
live? Are we live on YouTube?
We are live now.
Okay, we'll get started. Good morning, everyone. This is the June 10, 2021 meeting of the Board of Land and Natural Resources. Thank you for joining us. It is 9:03 a.m. We're holding the meeting on Zoom due to the ongoing COVID-19 situation and because it is an opportunity for people off island to participate. Those who are applicants or have signed up to testify in person will be in the waiting room until your agenda item is called. And please make sure your actual name is listed as your name in the computer in the waiting room, and also, if you can, your agenda item. People who are joining us for general purposes and listening are able to join us by YouTube. I will read the standard contested case statement. Member Gahn will be joining us in a little bit here. It's the standard contested case statement. In some of the matters before the board, a person may wish to request a contested case hearing. If such a request is made before the board's decision, then the board will consider the request first for considering the merits of the item before it. A person who wants a contested case may also wait until the board decides the issue, then request the contested case after the decision. It's up to you. Any request must be made in writing within 10 days. If no request for contested case is made, the board will make a decision and the department will treat the decision as final and proceed accordingly. Item D2 on the agenda has been withdrawn, so we will not be hearing D2. If you're here for that item, you can go about your day. And first up, we have the minutes from the April 9, 2021 meeting. Board members, any comments to the April 9, 2021 board meeting minutes?
Why don't you make it louder? It's okay, I can hear.
Hearing none, and there's no public testimony on it. Is there a motion to approve the minutes?
Move to approve the minutes of April 9, 2021 as submitted.
Thank you. Is there a second?
Second.
Second, Mr. Char. All in favor, say aye. Aye.
Aye.
Okay, and for the record, that is Case, Oy, Char, Yoon, and Gomes. Thank you very much. First up on the agenda, we have C1. Darlene, can you help me with getting people in from the waiting room, please? Darlene, are you there? Oh, there we go.
Getting them in.
Yeah.
David Smith's not in. He's not on. He's not in the waiting room. Emma's going to give the presentation, I believe.
Yeah, aloha, this is Emma Ewan from Division of Forestry and Wildlife. And this submittal contains 2 proposed natural area reserves that we're trying to add. One is an
There you go.
There he is.
Okay. Are you going to do it, Emma, or is David?
He just joined.
Yeah, David, can you hear us?
Yep, just got on. So we're on C1?
C1.
Okay, great. Yeah, David Smith, Administrator, Division of Forestry and Wildlife. C1 is regarding a couple of additions to the Forest Reserve sections. One is for Pia Valley, Hanging Valley in the Southern Coast Laos, really important native and endangered species management area. This is one of the final pieces in a long process in getting this area donated and then added into our natural area reserve system. So that's a 300-acre piece. And then there's another really small piece out at Kind of Point near the Kind of Point Natural Area Reserve. And the proposal was to add that to Natural Area Reserve as well. I got Emma Ewan here, who's our Native Ecosystem Protection and Management program manager, and I'll let her add anything else, and she can probably answer any questions that you have. Thanks.
This is Emma Ewan again, Division of Forestry and Wildlife. I just would add that primarily the testimony that we received was in support. There was an opposition piece for PIA regarding the opposition to building more fences, and there was concern in a point parcel about restricted access. And we have provided some background on how the importance of native coastal restoration in Ka'ena and how the Natural Area Reserve System does manage primarily for protection of native ecosystems. And so while we don't have specific plans right now for restricting access and that sort of thing, that will be the goal of the Natural Area Reserve System will be to restore the coastal vegetation largely similar to how it has been restored in an area that's currently protected from vehicles in the western part of the point. So we're here if you have any questions.
Thank you. Any questions, board members?
Here I have.
Yeah.
In some of the testimony that I've read, there's some local fishermen are asking access to be able to go and fish. Will fishing be allowed in any of those areas?
Yeah, the designation of the NAR doesn't actually stop fishing, and currently people are fishing within the existing Ka'ena Point Natural Area Reserve too. The main concern that these folks have is the ability to drive right up to their fishing grounds, and a concern that vehicular access is going to be blocked, similar to how it was blocked at the westernmost part of the point. And while we don't have any specific plans right now to block vehicle access, we will be adaptively managing the area and determining if there are ways to protect that coastal vegetation from vehicles, which is currently being trampled. And there's Eevee kupuna, there's rare plants, it's good seabird habitat. And so it is true that vehicles right now are the main threat to that region that is between the proposed NAR and the current vehicle barricade, which is about 8 acres of potential native coastal habitat that could be restored.
So saying that, Emma, how are you going to enforce that for these vehicles and so forth? We're kind of understaffed with that, but do you have any plans to how enforcement will be handled with this illegal vehicles or what they're doing?
Currently, the state parks have worked with the community to designate existing agreed upon corridors where folks are supposed to drive and park. But you're right, there is issues with enforcement and people are going off road. And so there is a question of how we can incentivize folks to stay on the road. And one of the ways is to improve the existing Malco Road that people are straying from because it's so bad and it gets really terrible in the winter time. So that's kind of one passive way that could be used to try to get people to stay on the agreed upon roads. And then, as I mentioned, the second way that would, we'd have to consider in the future, if that doesn't work, is to try to find ways to pinch off certain areas to discourage driving all along the coast.
Okay, Appreciate that. Thank you. Just for staff, on our agenda or the photos, it's really dark. The clarity is really, really bad. I would like to see a better clarity of pictures. It's just plain black and white. I can't really see definite areas.
Okay,
It just-
yeah, I'm sorry it got transferred into black and white. I'm not sure how that happened.
All right, thank you.
Any other questions?
Chair, I think Marigold had to say something.
Marigold, we're on C1. Did you want to add something?
Oh, sure. Thank you. Marigold Zoll, Oahu Branch Manager for Forestry and Wildlife. As you all are probably aware, we had quite an extensive public outreach process when we initially designated the roads in the state park and in this area. And we also have, State Parks has an interpretive technician that's stationed out there, and she has a good working relationship with the fishing community. And so before we would do anything that would change where vehicles are allowed to go, we would launch an outreach campaign to get input and try to come to some solution that has community input. So I just wanted to add that.
Great, thank you.
One last thing to add is just to recognize again the Tom family as well as Patricia Godfrey, who are the donators of these two parcels.
Yes, they have come before the board in different parts of this process, but they have been very generous in making these lands available, now donating them to the state for the public. So we very much appreciate that. Hugely generous and meaningful contributions to protecting our natural areas. Okay, any further questions, comments? If not, is there a motion to approve C1 as submitted?
Move to approve C1 as submitted.
I'll take Mr. Char made that motion. Is there a second?
Second.
Thank you, Mr. Gomes. All in favor, say aye. Aye. Thank you. And that is unanimous, noting the absence of member gone. Thank you. Let's move to C2.
Okay, C2, again, David Smith, Administrator, Division of Forestry and Wildlife. C2 is a request to adopt administrative sanctions schedule for the processing of forestry and wildlife resource violations. So this is the civil violation program that we've been working on. It's intended to streamline the citation process so that we just have it run through the board. Some of the fine amounts and whatnot are less than we could potentially ask, but the idea is to provide disincentive to folks for rules violations in the first place, and then to maximize our efficiency in terms of moving it through the system. So let's see, Marigold's been working on this extensively along with Catherine Stanaway. We've vetted it through DoCare, Jason Radula, Chief Radula, and others. And so I'm going to hand it over to Marigold and the team to run you through and then be available for any questions because it's a little technical. Okay, thank you.
Thank you, David. Marigold Zoll with Division of Forestry and Wildlife. Yeah, I got involved with this issue when the albatross incident happened out at Kaena Point. There were a number of adult animals that were killed and eggs that were smashed, and I learned about the fact that the DoCare officers don't necessarily have a good way of just providing a simple ticket to people who violate forestry and wildlife rules. And that presents a gap in the law enforcement toolbox, because they can either give a warning or they can give a criminal citation that has to go before a judge and it could result in potential like criminal record and stuff. So this presents just another tool for officers to use. And I will hand it over to Catherine. She has a PowerPoint presentation to kind of run through the technical aspects of this. We've been working on it for about, I'd say, 5 years or so. So we're really happy to come to you today with this for your consideration. Thanks.
Good morning, Chair, board members. My name is Catherine Stanaway. I work as the law fellow for DILFA. And is there a way I can share my screen with you folks for the presentation?
Go ahead.
Okay. Sorry, I've got to go into my system preferences for a second. Sorry about the delay.
Take your time.
I think I might have to log in from a different computer. I'm not sure how to, not sure why it's not working on this computer.
Catherine,
Yeah,
if you have it in the background on the computer that you're on,
okay.
put it in the background, and then you go down to the green screen, the green button at the bottom, or it could be at the top of your screen, where it says share screen on the Zoom page.
Yeah, it's, I'm getting a like a little triangle for the desktop and an exclamation point that's saying it's not sharing my desktop. I'm not sure why.
Catherine, this is Emma. You could email it to me and I could share it if that would be faster.
Let me try one more thing.
No, we could put you on hold and go to at least D1 while you sort it out. Let's see if we can just give you a little time to work it out. So we'll leave you in here and we'll switch to and go ahead and try sharing screen if you want to. You can quickly undo it. All right, hang on one second.
Okay, thank you.
Okay, Russell Suji, are you connected?
1 second. Yeah. Yes.
Okay, let's go ahead with D1, please.
Okay. D1, requesting a right of entry for the USDA, U.S. Department of Agriculture, for going on to some unencumbered, actually encumbered lands out on the Big Island, mainly a few of them encumbered by those pasture leases up towards the Mauna Kea side of the island, and some unencumbered lands for a survey of the reserves. I needed to make an amendment just to clarify a small change on page 3 and exhibit B on the 343 exemption. They changed the heading of it. The text of it and the substance of it is all the same, except the heading changes from exemption class 5, number 1, and instead of that to general exemption type 5, part 1, item 13. So no substantive change to that, but it is changed, noted on page 3 and also page 2 of exhibit B. Other than that, I don't have anything to add on this submittal. Thank you.
Okay, questions? Board members? No questions. There's no public testimony on this. Is there a motion to approve D1 as submitted?
I move to approve as amended.
Second.
For that, all in favor of the motion to approve as amended?
Aye.
That is unanimous, reflecting the absence of member Gahn. Okay, let me bring one person in for D3. Two people. Okay, I think you can go ahead, Russell, for D3.
Okay, D3 is just requesting the board to consent to mortgage and to issue an estoppel certificate related to our Diamond Head Theater lease to it's a nonprofit lease up at Diamond Head. A few years ago, they came back asking for a new lease in order to get enough term to go on a major fundraising for some improvements to the theater. And in this case, they're also asking to take out a loan up to, looks like it's up to $2 million for construction of the theater. We're asking for consent to the board, and also on the estoppel certificate, delegation of authority to the chair to negotiate the terms. We'll be referring that to the Attorney General's office to double check it meets the state's conditions. Other than that, I don't have anything to add on.
Okay, the applicant is here. Do you want to add anything?
We would appreciate consideration of the mortgage. We have been raising money and planning this since 2007, and construction has already started. The total cost is about $22.5 million. Diamond Head Theater has funded through operations and savings over the past 15 years, $4 million of that, and we've raised $15 million, so a total of $19 million kind of in our pockets. The $2 million mortgage is an abundance of caution. We would like to get the money through philanthropy, but we want to be able to proceed with the construction as scheduled. So the $2 million gives us a backstop in case we need it. That would complete phase 1, which is the new theater right next door to our current theater. And then we would demolish the current theater, landscape the grounds, and rehabilitate the back building, which we're calling the Theatrical Arts Building. And that would house education studios, the costume shop, and administrative offices. We would appreciate consideration of the consent.
Thank you. And could you please state your name for the record?
Dina Dre, Executive Director, Diamond Head Theater.
Thank you. And Mr. Miwa, anything you wanted to add? You're on mute. You're on mute.
Thank you. No, I don't have anything to add. Thank you very much.
Thank you. Okay, any questions, board members? There's no other public testimony. Mr. Oy, and then Mr. Char.
For the applicant, is Diamond Head Theater considered a historical building?
No, it is not. We have had a ruling and it is not a historical building.
Okay, thank you.
Mr. Char?
What would the term of the loan be for? How many years?
25 years.
Thank you.
Any further questions? If not, is there a motion to approve D3 as submitted? Mr. Char moved to approve. Is second, Mr. Oy. All in favor, say aye.
Aye.
All right,
Aye. Thank you. That's unanimous, noting the absence of member Gahn. All right, good luck to you.
Thank
Right,
you.
Thank you. Thank you. Thank you.
All right, we'll check back with Forestry and Wildlife now for C2. Are you ready to go?
Catherine's ready. I think she just needs to be let
Okay.
back.
Hang on. Okay, go ahead when you're ready.
Okay, sorry about that. Okay, let's see if this works this time. Okay, can you all see my screen?
Yes.
All right, good. Okay, so with this presentation, we wanted to give you folks some background on what CRVS is and how DOFA's guidelines fit in. So, CRVS stands for Civil Resource Violation System. And so, oops, I think I have an old one. Okay, so let me start out with what CRVS is before I go into the slide here. So, DLNR's CRVS was established by Act 142 in 2004, and it's codified in Chapter 195D HRS. And then the department has adopted administrative rules for CRVS in 2009, which are codified in Hawaii Administrative Rules 13-1-51 to 72. And then the purpose of CRVS is to process violations of the departmental regulations for which administrative penalties have been authorized by law or rules adopted thereunder. So all divisions within the department they have the option to adopt administrative sanction schedules through board approval for the adjudication of infractions with an administrative penalty. So now we go on to this slide. Why does DOFA want to add to DLNR's existing CRVS administrative sanctions schedule? So DOFA's guidelines, they expand the scope of the department's guidelines to include many forestry and wildlife infractions. They offer guidance to the department's enforcement functions in the issuance of civil citations by one, providing a list of violations with an administrative penalty that are subject to the department's administrative hearing process, and two, highlighting maximum administrative fines available for first offense and repeat offenders. So with these guidelines in place, the department would also retain the option to prosecute violations through the criminal system or board action when appropriate. So our thinking is that if this were in place, Hawaii's environmental courts would then be more likely to hear the more egregious forestry and wildlife criminal cases. So actually I had another slide before this too, but it outlined our statutory authority to apply these administrative penalties. So I'll just go through that. I apologize. It's in the board submittal. I apologize that it's not on the slide. We have 5 different statutes that apply to forestry and wildlife infractions and violations. Chapter 183 it applies to the forest reserve violations. And so HRS 183-5 authorizes maximum administrative fines of $2,500 for a first violation, $5,000 for a second violation, and $10,000 for a third violation. These are for sections in 183D or any rule adopted thereunder. So like I said, like our regulations for forest reserves. And again, these numbers I'm giving are the maximum administrative fine allowed by statute. They're not what we've incorporated into the sanctions schedule, but they're just giving you an idea of our authority. The next statute, 195D, authorizes is our threatened and endangered species regulations, and 195D9 authorizes a maximum administrative fine of $2,500 for a first violation, $5,000 for a second violation, and $10,000 for a third violation. And these apply to sections of 195D HRS and any rule adopted thereunder. Chapter 183D is our hunting regulations, and HRS 183D12 authorizes a maximum administrative fine of $10,000 for first violation, $15,000 for a second violation, and $25,000 for a third violation. We've applied them to our hunting section, two sections of our hunting statutes and administrative rules. And then chapter 195 is for the natural area reserve. And so HRS 195-8 authorizes a maximum administrative fine of $2,500 for a first violation, $5,000 for a second violation, and $10,000 for a third violation. And we've applied those to sections of 195 HRS and rules adopted thereunder. And then finally, our last authority comes from chapter 198D. And so the section is 198D-12, which authorizes a maximum administrative fine of $2,500 for a first violation, $5,000 for a second violation, and $10,000 for a third violation. And we've applied that to sections of 198D and any rule adopted under that. So, so the benefits of DOFA joining into DLNR's existing civil resource violation sanctions schedule are, it provides fair, fast, and cost-effective enforcement measures. The matters are processed as civil proceedings through DLNR's Administrative Proceedings Office, and they have the standard fines, which are outlined in the schedule. And this is instead of going through criminal proceedings through Hawaii's district courts. These offer more uniform imposition of penalties, quicker dispositions, and less burdensome evidentiary standards for these administrative fines. So throughout this presentation, I've called these DOFA's guidelines, and they're called guidelines because, well, they're a part of the larger CRVS administrative sanctions schedule for the department. So it'll be included as part 7. And the fine amounts shown on the schedule are the maximum fines that a suspected violator may be charged by the department. So in developing these guidelines, DOFA program staff thoughtfully decided on maximum fines for each category to make fines high enough to penalize violators, but low enough that violators are more likely to pay rather than fight the violation. So in a case-by-case basis, the maximum fine may be able to be reduced by the Administrative Proceedings Office if the respondent contests the fine and provides adequate mitigating circumstances. So DOFA's guidelines have 6 categories. Category 1 is for non-extractive violations. Category 2 is for extractive violations. Category 3, safety violations. Category 4, commercial activities violations. Category 5, permit or license violations. And category 6 are species in need of conservation and threatened and endangered species violations. So I'll go into these more in a second. Okay, this table outlines the 6 categories and then the fine and the late fine, which is so the fines must be paid within 21 days or else a late fee applies. So our lowest category fines are for category 5, and these are the permit or license report violations. And this is where we require reports to be filed, but as a part of, as either statute, administrative rule, or a condition of a permit. And with a first-time violation would be $15. Second-time violation within 5 years would be $25. And a third-time violation within 5 years would be $100. So category 1 is actually our second lowest fine, and these are extractive violations. We call them this because in this category, violations do not remove or damage regulated natural resources. So a first-time violation would be $100, second-time violation $200, and third-time violation $500 or $400, excuse me. And those are the second and the third-time violations have to be done within 5 years of the previous. The second category is called extractive violations, and those violations within that category, we consider them to cause damage or remove natural resources. So a first-time violation would be $250. Second-time violation within 5 years would be $500. Third-time violation within 5 years would be $1,000. The third category and the fourth category have the same fine structure, but they're different categories. So category 3, we call these safety violations, and because violations in this category will risk the health, safety, and welfare of persons and or natural resources. So first-time violation would be $500. A second-time violation within 5 years would be $1,000. And a third-time violation within 5 years would be $2,000. Category 4 is for commercial activities violations. This also includes hunting guide activities without a license. So this would be, again, first-time violation of $500, second-time violation within 5 years, $1,000, third-time violation within 5 years, $2,000. And then our final category is category 6, and that's our highest fines for species in need of conservation and threatened and endangered species violations. So here we applied the maximum fine allowed by statute because of the potential to affect populations of native wildlife. So the first-time violation would be $2,500, second-time violation $5,000, and third-time violation with $10,000, and that's all each within 5 years of the previous violation. So, okay, yeah, so I apologize, I don't have the slide on here either, but we have examples that wanted to give you of each category. So category 1, non-extractive violations, our examples are no camping in a forest reserve or wildlife sanctuary without a permit, and no entry into a restricted area or closed area in a forest reserve, not Alaheli Trail, wildlife sanctuary, or natural area reserve. So again, those are our second lowest fines of $100, $200, and $400. So then the second category, extractive violations, example of that would be abandoned property left in a forest reserve, wildlife sanctuary, or no Alaheli Trail, or starting a fire outside of a receptacle in a forest reserve, public shooting area, or not Alaheli Trail.
Are those the non-extractive ones?
The ones I just listed are extractive. Yeah, the second category. Yeah.
Okay.
These are all in the schedule attached to the board submittal. So I apologize. I think my other slide is on the other computer. So category 3 are the safety violations. And these examples include starting a fire in windy conditions in a forest reserve, or using explosives in a forest reserve. category 4 example of commercial activities violations would be conducting commercial activities in a wildlife sanctuary or natural area reserve without a permit. Category 5, again, are our permit violations that our report violations that are authorized by statute, administrative rule, or condition of the permit. And then category 6, again, those are highest fines, and so most times violations of threatened and endangered species would be processed as criminal violations by the court or board of action because we consider these to be egregious violations. With HB 1022 just signed into law, allowing administrative inspections, including category 6 in DOFA's guidelines, would allow administrative fines for such violations if found during a lawful administrative inspection. So DOFA worked with the Administrative Proceedings Office and DOCARE in developing our guidelines. And APO, their Administrative Proceedings Office, their role in enforcement of the guidelines is to manage the administrative hearings process, work with DOFA to issue administrative citations for category 5. And APO and DOCARE have been working together to see if they can link their databases so we can track repeat offenders to be able to apply that fine structure. And then DOCARE's role, so the officers would be trained to use their discretion when issuing civil or criminal citations for a violation included in these guidelines. Officers may issue administrative citations for categories 1, 2, 3, 4, and 6 in the field. And we've attached the notice of violation to the board submittal that they would be using. That's as draft right now, and we plan to run that by the AG again before that would be used. And if the submittal is approved, then DOCARE would first implement a like mini condensed version of this, because there's over 200 statutes and administrative rules within the sanction schedule. So we want to make sure we kind of get the kinks out beforehand. So there, one person in each branch would be designated to issue civil citations in addition to the criminal citations they can issue. That person would enter those data from the civil citation into CODI. And then this way, DOCARE could work out any problems on the smaller scale. And then once the initial rollout is determined to be successful, it would be followed by more comprehensive training for all DOCARE officers. DOFA is currently working with a vendor to develop ticket books, and we've been working with APO and DOCARE to make sure those are within their standards. So finally, if approved, our next steps would be to finalize the rollout strategy I just discussed with DOCARE, finalize any database issues for linking their APO's database and DOCARE's database, CODI, send DOFA's part to the prosecutor's office and environmental courts. This would help inform the judges on how DOFA staffs value certain infractions that have been committed and value some of our resources. Want to train DOFA staff in understanding the guidelines. And our understanding is fines collected would go into the Natural and Physical Environment Special Fund, which is established under HRS 171-19. So, OHA offered some comments after we submitted the submittal, and they had requested we include a note at the end of the sanctions table to indicate Native Hawaiian exercising traditional and customary practices would not be fined, as such rights are protected under the State of Hawaii Constitution, Article 12, Section 7. and concluded that this isn't necessary to add because those rights are already protected by law, and we didn't want to add confusion to the submittal.
And,
So-
and are subject to reasonable regulation by the state.
And they also requested DoCare undergo annual cultural sensitivity training, and our understanding is all new officers receive training as part of the academy. And at this time, DoCare is not going to implement cultural sensitivity training, but maybe that's our understanding. And that's it for our presentation.
Thank you very much. Marigold, do you want to add something?
Yeah, the way we've structured this, it's not restricted to just DOFA CRBS, the fine schedule. It could be used for any of the divisions, and the ticket books similarly can be used for any of the divisions civil penalties. So we tried to make the application really broad for the department.
Thank you. Any other staff want to add anything else at this time? Okay, let's go to questions from the board members.
I have, Chair.
Go ahead, Mr. Gomes.
Just my thought process in the category 1 fines, in various as non-extractive and areas of the category 1, like alcohol, drugs, intoxication, human waste, disorderly conduct, firearms, domestic animals. My thought process is, why can't category 2, the fines we have in category 2 for fine, first offense, second offense, third offense, be the same as raise category 1 to category 2 violation amount, rather than being category 1 is less than category 2. Because I think if it's non-extractive, it is a determining case that it's very ongoing. And I think due to the fact of lack of enforcement and getting out there and catching them, it's just a slap on the wrist. If they see that this fine is we mean it, maybe they're less apt to do it. But that's just my thought process.
Yeah, I guess I just respond that we wanted to have a graduated fine amount. And our thought was that we would try with this schedule and see how it goes. We also didn't want folks to, the initial amount to be so high that they wouldn't be willing to pay or couldn't pay. And so it was kind of a balancing act to try to find a fine amount that would send the message, but still not result in a lot of requests for hearings from the.
Will this go out for public hearing?
This is the process.
Okay.
Yeah.
Okay, because it's just for me, educate the public, and this is where we at, and this is what's going to happen. Boom. That's just my thought. Thank you.
Other questions, board members?
Yeah, I have a bunch of questions. I'm really happy that DOFA is doing this. And I like most of it. I have some specific questions, though. But one thing I really don't understand, what is, say a DoCare officer is patrolling the forest reserve and they see a guy taking a log out of the forest reserve. What do they do right now?
My understanding that they have two things that they can do. They can either warn somebody or they can issue a criminal citation. It's generally what happens. And so in this case, they would have the discretion to offer, to issue a civil penalty or a criminal penalty or a warning. Which give them another tool.
And so they can just write. My understanding of how this is supposed to work, CRVS, is that they just write it there. It's like a parking ticket. They hand it to the person, and they got either, I don't know how many days to either contest it or pay it. If they if they contest a civil thing, it goes to a hearing officer that with the DLNR. If they contest the criminal, it goes to the environmental court, it goes to a judge, right? All that's correct. So it's good to, be able to do something for the doe care officer to be able to do something on the spot while they have the person right there. My second question that's kind of related is, how is the decision made of what violations are handled through CRVS and what go to the board? Because we see, violations that, at the board, and I'm not really sure, but I'm guessing that the vast majority of infractions are not being brought to the board. They're being handled, I hope, more informally through something like this. How does that decision happen?
I think I can answer that, Mr. Ewan. Good morning, Chair and board members. Jason Redula, Enforcement Chief, Doe Care. So, as Mr. Ewan pointed out, essentially what CRVS is another tool in the enforcement toolbox. Along with that enforcement tool in that toolbox is the criminal side of the house, which consists of criminal citations and arrests. And on the civil side of the house, we have CRVS and board civil enforcement through board submittals. As you point out, the idea here is if we use CRVS, when officers come upon a scene and a violation has occurred, they're going to have to make an assessment of what tool to use at that time. And if the situation is relatively minor, not very egregious, they may choose to use the CRVS system, whereupon, as you point out, they would take the CRVS citation and issue it for that particular violation. That violation would then be processed, and if the person doesn't pay the fine, they would be referred to the Administrative Proceedings Office, where they're going to have to undergo a hearing. It's a little bit different in that with board submittals and board level enforcement, that's usually done for pretty serious violations, where divisions will actually submit a board submittal and come before the board and make their case. And vastly different from the criminal side of the house, where a person either receives a criminal citation or gets arrested, and that's how it gets intake into the criminal justice system and is referred to the environmental court if it doesn't get played out before that. So really, the situation comes down to the assessment of the officers at the scene and wielding the appropriate enforcement tool at that point.
Okay, so the officers are, they have some training that will tell them if somebody is found with, 10 turtles, endangered hawksbill turtles in their possession. That's not, don't just write a little citation. We might want to take it to a supervisor and see if that's going to be dealt with on a board level.
So I think when we assess a situation, and in the situation you pointed out, given the totality of that facts and circumstances, my expectation would be that the officer would consider that very serious, and really the appropriate action to take at that point would either be to issue a criminal citation or to place that individual under arrest for those violations. But again, a lot of this is situational. It's going to depend on the facts and circumstances presented at that time, whether in fact, especially on the criminal side, there's always a state of mind component. And when we're looking at probable cause to take enforcement action on the criminal side, we do have to consider the state of mind and the facts and circumstances that's presented to us, whether it was intentional or not. If it was unintentional, you know, using a criminal action like arrest or criminal citation might not be appropriate. But again, it is an assessment of the totality of circumstances presented to the officer at the time.
Okay, so then my next questions that I have deal with the per violation versus per specimen as a measure here. And I looked at we have, what we were told a few minutes ago, there's 5 statutes that list maximum fines that are administrative fines that are available. One of those 5 allows which is the endangered species, has a statement that you can have a fine of up to $5,000 in addition to the $2,500, which is what's in the submittal. It says you can have a fine of up to $5,000 per specimen. We've been, when we've been doing these for aquatics, we've been taking a per specimen fine, and that statute, which is 187A, does have specifically say per specimen. Can we, I think like for an endangered species, which is 195D, that's pretty serious, and we ought to have a per specimen fine that's available, and so that we can max out the fine for the endangered species. Anybody want to respond to that? Is that am I misreading something? Was there a decision not to go for the 5,000 per specimen?
My understanding that it is on the per specimen basis and it's on the per incident basis. So you could have multiple violations for one ticket. If somebody was camping without a permit and they had a ground fire, you could issue, a citation for each of the infractions. And similarly,
I'm sure that that's true. Yeah. I was going to get into this question of, like, if you take 10 logs, which is okay. So in the forest reserve, you don't have the statute doesn't say per specimen, all right? But I think that if you take 10 logs, you can say that's 10 violations, because that's 10 separate acts of taking, you cut a tree, then you cut another tree, and then you cut another tree, and those are all separate violations. But I think that if you look at 195D-9E, the submittal cites 9D, which has $2,500 per violation as a maximum. But if you look at 9E, it says, in addition, the department can have a fine of $5,000 per specimen. And I'm thinking that we should have that in in our administrative penalty section, unless there's some, unless I'm missing something, why we shouldn't say 9,000 per 5,000. First of all, it's bigger, than 2,500. And I'm not sure that in every case, you can say that taking something is taking 10 of something is 10 separate violations. And I'm not thinking, I don't have a good example in the endangered species area, but I'm thinking in the aquatics, for example. Somebody sets a net, they're illegally aquarium fishing, and they have this fine mesh net. They set the net, they catch 100 fish. Maybe that's one violation, but there's 100 specimens. Whereas in the example that I gave when cutting the trees, you cut 10 trees, you did 10 different things and you have 10 violations, you see. But I'm back to, you know, on specifically on the fee schedule for the threatened and endangered species. Shouldn't we have this $5,000 per specimen and make it, you know, I can't imagine that we, you know, there's some, you know, like plants that maybe you take, you know, maybe you wouldn't necessarily, you never have to necessarily take the maximum, but I'm thinking most of our endangered species, if somebody takes it, you would want to have the option of the maximum per specimen fine.
Yeah, we could add that. And then we could also, it seems like something of this nature would be so egregious that it would come to the board anyways. And so I think that was our thinking, was that with endangered species violations, especially, we would want it to come before the board for action. But we could certainly add that provision to the fee schedule. Or you could add it.
Well, yeah, I would like to see it even if it comes to the board, because when we have these things come to the board, the submittal usually cites the CRVS as well. So it, you know, if it says, you know, for the fish one, for example, the aquatics, the fee schedule is less than the maximum per specimen that's allowed by the statute. And so we normally are following that lower amount, even though, you know, we don't have to. So I think that we ought to stick that in there for the endangered species.
Can I ask just a clarifying question? When if the fee schedule for, say, endangered species is less than the full amount, how in this system, how do you decide whether to go through this citation system or bring it to the board at that stage?
So I can clarify a little bit. So originally we didn't have category 6. Originally we were only going to have T&E species violations either be prosecuted criminally or by board action, because we consider them so egregious. We added that in there mainly because of HB 1022, the administrative inspection statute that was just signed by the governor. So under, if threatened and endangered species were found through a lawful administrative inspection, then with these guidelines in place, that person would also be able to receive an administrative citation for the take of a threatened and endangered species if found in their possession.
Good morning, Chair and members of the board. This is Ben Lee. I manage the CRVS system. I just want to address that question a little bit in regard to, you know, the criminality of a specific case and who makes that decision to take the case to the board or through the system. And I think what Jason just said was basically correct, and that's what we've been following. So normally the division chief or the dog care officer would make the decision whether to take it to the board or take it to the system or to the court. So they do have that discretion in making that decision. Now, in regard to endangered species and some other high-profile cases, we normally have the understanding, you know, that they should rather go to the land board instead of the system. So what we're dealing with here is a lot of those minor ones that are clearly low in criminality, and in many cases are, you know, violations by visitors who may not stay here for long. So they are kind of eager to, you know, take care of the case and be done with it. So but then in some cases that might kind of involve like some regular but more egregious cases like OCCL has been doing. So those are, you know, much higher fines, but it's less likely that it would be repeated. So we're not dealing with repeat offenders. And if that is the case, most likely we also take it to the land board as well. So, I mean, in short, the division or dog care officer could, and they should make the decision. Normally, we don't have a big problem with that part.
Hey, Chris, are you done?
No, I have, if you don't, I mean, go ahead. I can.
No,
finish.
go ahead, Chris. Go ahead.
So, okay. Well, I think that just because, just so it doesn't get lost in the shuffle, I think we ought to add the maximum 5,000 per specimen for endangered species. I just wanted to make a comment too about repeat violations, because I raised this question in a fine that we had, a land division fine, and it was the question was, okay, somebody does something on day one, they make they do a violation day one, and then a second day they do it, and then a third day they do it, and then it's brought to, is that like three different? Can you do the enhanced penalty? There's an enhanced penalty for the second violation, third violation. And I wondered if it meant that you had to have first been adjudicated and found guilty of the first violation before you considered the enhanced penalty for the second violation. And we were advised by AGs that we could, like, if we had these three violations, the second day would be enhanced penalty, and the third day would be enhanced penalty, because as long as we found them guilty of all three, all right, it doesn't have to be like three separate adjudications. And I did do some legal research on that, and I think that is correct based on some Hawaii Supreme Court criminal cases. So if we adjudicate, so in other words, that the officers, this should be actually part of their training, that if you catch somebody, it doesn't have to be that they were found guilty of something within the last, year or 2 years or whatever. If they do something bad once and they do it again, and you can prove it both times, the second time is a second violation and subject to the enhanced penalty. And so I just want to make that comment because it's something that I had brought up on a previous issue. Now, just a couple of real specific questions. Why are only 1 or 2 officers per island going to be doing these DOFA citations?
I'll answer that again, Mr. Ewan. Jason Redula, DoCare Chief. So the idea right now is to kind of test the process to see where all the kinks are in the system. We do expect there's going to be glitches in the flow of how this process is going to work. And we want to find them out so that we can correct it and make the process smooth and efficient. That process will also include, as you point out, training for the officers, as well as ensuring that the database that connects to the CRVS system at the Administrative Proceedings Office and DoCare's record management system are linked up and tied together, so that when officers do contact violators, and we do have to check whether this is a first offense or a second offense for this particular violation, we can do that relatively easy in the field.
Okay, so then another question that's real specific is, why are the officers not going to cite category 3, which is safety?
Actually,
they
sorry,
are.
they are going to cite category 3. I think it's category 5, the permit or licenses where DOFA would have that information, would be the one category the officers would not cite for in the field.
Okay, I must have misread the slide then. And then they won't cite for category 6, which is threatened or endangered under CR. They're not, at least at first, going to be told to cite for those. Those are going to go criminal. or board, and or board.
Yes, sir, that's my understanding.
Yeah, I heard a couple of times, and I don't know, people were maybe not speaking precisely, but we can do both. You can cite, and we have done both. You can cite criminally and you can cite civilly. So let's not forget that that's an option. And then just a couple of real specifics ones. The fine for archaeological sites for $250 seems low. This would only be an archaeological site under DOFA, like if there was an archaeological site in the forest reserve. But it does seem low. Is there a way to, I don't know. That's my comment. Anybody have any thoughts on that?
We could look at the language of the rule again that you're referring to and reassess it.
And then finally, the fire, if sometimes it's treated as it's a category 2 and sometimes it's a category 3 safety. And I tried to look at them and they do make sense, but say lighting a fire outside of a receptacle in the forest reserve is an approved spot, is a category 2, but lighting vegetation on fire is a category 3 safety. Aren't all fire violations really safety violations?
Yeah, we kind of struggled with that because it seems like there's some, circumstances that play into this particular kind of situation. And so, somebody having a ground fire in a place that would otherwise be, not dangerous to the surrounding vegetation might be a category 1. Whereas if somebody lit, a giant bonfire on the edge of the forest and red flag conditions, it would be, a more egregious offense. So it would give us some flexibility, or the officers flexibility in that.
Okay. Well, I just want, feel that you've thought about the fire situation. The final thing is you talked about ticket books, and I would think that the doe care officers would have one set of ticket books, and then they would fill in the citation number, or is it going to have like a DOFA ticket book and a DAR ticket book?
So I can answer that question again, Mr. Yuen. So with regards to the actual citation books, we do have criminal citation books that are issued by the judiciary. And this is what we use to summons people to court and how cases get intaked into the criminal justice system. For the CRVS side, what we're looking at is a department-wide CRVS citation book that will encompass pretty much all the divisions that have CRVS schedules. For example, DOFA and DAR, and use that same citation book with the violation notices in it, so that it's consistent throughout the department. If every division had its own citation book, it would be too cumbersome out in the field.
Okay, but don't they have a civil citation book now? Like say you have a DAR violation, like somebody has a unregistered net. They don't have a civil thing that they fill out to put it into the CRVS system?
No, sir, not at this point. We've not been using any type of civil citation in the field for that purpose. The only types of citations we've been issuing out in the field is the actual criminal citation book issued by the judiciary.
Huh.
Mr.
See, I thought the whole idea behind the CRVS was to have the officers issue these civil citations in the field.
That's
Yes.
correct.
Yes.
That's what we're going for in this, so that the officers can issue that ticket on the spot and have more effective enforcement action.
Mr. Yuan, I just want to add that we actually do have one version of the civil citation form that's been in use for quite a long time already. But that one is designed to be used by our divisions in-house. And we've been using that for DARS cases, OCCL's cases, and engineering's, and DOE boards in a limited scope. But that one is not to be used by DOE care officers in the field. And what we've been doing in the past, and now we have gotten the AG's blessing, is the form that's going to be used by DOE care officers in the field. It's basically modeled from our current form, but it's a little different, and apparently it's going to be, like Jason said, to be used by all DOE care cases that involve all divisions, not just DOFAR.
Okay, thank you. That's all I have.
Mr. Yoon.
Yep, thanks, Chair. I got a question for Chief Radula. Staff capacity, DOE care staff capacity wise, are you whole? I mean, are there open positions? How are you guys doing with that?
Yes, sir. To be upfront and plain about it, we are severely understaffed right now. I currently have 77 sworn officers. I have 42 vacancies.
Okay, thank you, thank you, Chief. And the comment is, I suspected as much. With a significant staff capacity issue, I think we need to be, and I'm all for having more tools in the tool belt, as you say, Chief. And I think we need to be back to Chair Jimmy's comments about if it elevates to the board level and we're going to hit them, you hit them hard. Because I'm afraid that a lot of these things, albeit I think this is a good program and a good initiative to deploy, with that amount of staff capacity, I'm just afraid that there's going to be a lot of slippage through the cracks. And I think this board in recent times, and I'm a new board member, but in recent times has been making strides in the right direction in exacting fines. So I guess the comment is, I feel for you, Chief Radula, and I think the board, we should consider this and any other tools that can help our DOE care officers, because it's situational out there and they got a lot of ground to cover.
Thank you for that. And I'll just say that even with DOE care's current level of staffing and capacity, it is the mission of DOE care to enforce the laws as much as we can, given the resources we have available right now. Thank you.
And I will add, we've had a tough financial year and are just starting to come out of it. Many positions were frozen and unfunded last year, and the legislature did fund a significant number of the DOE care positions for the coming year. So we appreciate that and are looking forward to staffing up, and in particular through the DOE care Academy for entry-level career intended conservation officers. Other questions, board members?
Well, Board Member Gon is now in the room and has been listening intently to this part of the conversation. I was really pleased to see this item, and I love the idea of consistent treatment across the conservation violations aspects of these things. And even though I wasn't there to hear Board Member Gomes' comment about about hitting violators hard when it comes to the board. I'm totally concur with that idea. And so setting this system up will mean that the most important ones to come before the board are likely to do so, where we can deal with that, and all of the other ones won't be just pushed aside, but now have a consistent method for dealing with them. So I'm very pleased to see this one.
Just to clarify, Ohu, he didn't say hit him hard. That was my paraphrase of what he was trying to.
Okay, well, but
the essence of what Jimmy was trying to say.
It was
Yeah.
consistent with behavior.
And I only paraphrase it that way. I mean, for the record, that our natural resources. I mean, we're one of the most biodiverse places on Earth, and we have to take this seriously because we're losing it, and we're running out of time. So, yeah, I think we need to take this seriously.
Absolutely, it is one of the largest kuleana of the sport.
Thank you very much for that. Are there any other questions? And I don't believe there's public testimony on this. No public testimony. All right, are we ready for someone to make a motion on C2?
I want to move to approve with an amendment that they add for the category 6, the $5,000 per specimen fine that's in 195D-9E, and it can track that language.
Thank you. Is there a second to that?
I'll second the amendment.
All right, further discussion.
I just wanted to mention say one thing about archaeological sites, historic properties. I think that the fine is too low, but I'm going to just hope that if you have a serious damage to a historic property that's in a forest reserve or in the natural areas reserve, that's the kind of thing that would be brought to the board, and we wouldn't be limited to the fee schedule, because you could fine considerably more, both under the forest reserve rules and also under 6E. That would be a historic property owned by the state. It would be a Chapter 6E violation.
Thank you. All right, we have
I have something just
Yep.
with reservations that I too would like to see on the fine level of category 1 be raised to category 2 for first, second, and third offenses, but that's just my thought. We need to sit and give some tools, like you said, put some tools in the toolbox for DoCare, but for the general public to know that we really mean business. So that's my thought process.
So I know that staff did think about that a lot. I wonder if there's you guys are going to be testing this process. We can always come back to the board if we think that that level is not high enough. Mr. Gomes, would you be open?
Yeah,
to
that's fine.
that?
I'm open for that.
Okay.
If it comes back and entertain that again, would be nice to hit it right now, but I hear you.
All right, any further comments? If not, all in favor of the motion as amended, say aye.
Aye.
Aye. All right, that passes unanimously. And for the record, that is Case, Gomes, Char, Yuen, Oy, Yoon, and Gon. Thank you, everyone, for all of your hard work on this. It's a big step forward, really important step forward.
Yes. Thank you very much.
Yeah,
keep up the good work, man.
Thank you,
Jason.
members.
You guys are wonderful.
Yeah.
Okay, we will be taking a 5-minute break.
Hey, Darlene, are you there?
Yes, I'm here.
Oh, sorry. I was gonna ask you to mute Vernon, but I guess you just did. Vernon had a train going by his house or something.
Okay, if we could gather again. We'll be moving on to item E1. Okay, just making sure Mr. Oi is here. Oh, we lost somebody.
I'm here.
We had Kurt, but
Mhm.
hang on. We had Kurt Control was in, but he got bumped out, so he'll have to log back in. Okay, Mr. Cottrell. E1.
Good morning, board members, chair. Apologies, I lost some connectivity. Kurt Cottrell, Administrator for the Division of State Parks. And E1 is we're requesting an amendment to extend and authorize DLNR through state parks to directly negotiate a 10-year lease extension with Camp Halikoa in Pu'ukapele in Waimea Canyon State Park. And before I get into the narrative, I feel compelled to apologize to both the board and to Camp Halikoa. I didn't realize that we were so far apart in our expectation of what the term of the disposition would be. And typically, I don't like to come to the board until we've worked through, a lot of those elements. So hopefully during the discussion, we can work through the disparity in terms of what the expectation is for the term. A brief history, you have it in the submittal, but yes, as Camp Halikoa testimony reflects, in 2010, roughly when I came into state parks from Forestry and Wildlife, that camp unit had been abandoned for quite some time and was in a very derelict condition. Abandoned vehicles, buildings were collapsing, and immediately started putting the word out and working with other community folks trying to determine who would like to take possession and manage it as a camp. And you guys have that history in the narrative. Ultimately, we worked with Camp Halikoa first on an RP, and then that transitioned into a general lease of 10 years. As the board reflects, and as Camp Halikoa says, yeah, they did a lot of remarkable improvements, particularly the interior of the bunkhouses. However, in their zealousness with community and volunteers, per the lease, there were some authorizations that didn't occur, but state parks didn't follow up on any penalties based on the executing work absent the written authorization. But of keen importance is we do have historical guidelines for Kokea Waimea in terms of the architectural elements in that park to maintain that historic kind of fabric of those two park units. Then fast forward to 2019, we got the Environmental Protection Agency notice of violation for large capacity cesspool, both in that park unit, another one, and then there was a third deal on our property. And so we notified Camp Halikoa that due to that notice of violation, they had to stop operations. And then the pandemic came shortly after that, which added a further wrench to having any type of camp activities due to all the obvious protocols associated with public safety with the pandemic. We did indicate during conversations and correspondence that they could operate with temporary measures, porta potties, exterior rinsing showers and whatnot, but for all the obvious reasons that would be inconvenient and very costly. So Camp Halikoa did not agree that they would continue in that fashion, and we understand. There's been a lot of interest from both legislators, the camp, some members of the community for state parks to bring this to the board sooner because the Camp Halikoa has offered on their own nickel to do the IWS construction. But I didn't feel comfortable, and the state parks didn't feel comfortable bringing this to the board until we finalized the EPA settlement, which just recently got finalized. The fines have been paid, and that is a kind of a sensitive spot because from what I understand from Land Division, typically the tenant would be the one that would be responsible for paying the fines. But there's a couple, I think, extenuating elements to this that has us now asking the board to approve that the state pay for that fine. First off is when we started looking at the property in 2010, I was unaware that there was large capacity cesspool violations there, or that they even had an LCC. And while the tenant typically is supposed to do their due diligence, there was never any discussion when we went from RP to lease in regards to the LCC in place. And second, because they're an eleemissary organization, say, versus a commercial, and that they're offering the IWS, we think it's in the best interest of the state due to our financial situation to have the state pay the fine, which came out of the Special Land and Development Fund, in exchange for the tenant now then putting in the IWS, which they have to replace three LCCs. Typically, from what I understand, most of the work and improvements have been volunteer donations from both the church and the local community. And one of the new elements that I just saw in their testimony is they're looking at taking out a loan and the various amortization schedules in terms of, paying back, that loan. But I do need to inject an amendment for clarity, and I apologize because, we did try to move this pretty quickly. Just to ensure, and as long as the board agrees, on page 3, the last paragraph, the sentence reads, despite the indemnity language in paragraph 15 of the lease, DSP determined the public would best be served by waiving the obligation. And what should also follow there is to pay the EPA fine for the commitment of Camp Halikoa to install the 3 IWSs. It's a little vague when we say waiving the obligation, but that's the intent, that we think it's best served for the public for them to do the IWS, and the state covers the cost of the fine. So that gets us to essentially now we're looking at, they have a projected $300,000 cost to do the IWS. And I've been reviewing what we've paid for IWS statewide over the years. And the $300K for 3 is not totally out of line. What I did find a little discomforting on the proposals, I didn't see design costs versus construction costs. So that's something that would have to be worked out, because we need to ensure for both, EPA if they follow back with us, but for sure for Department of Health, that the IWS that they would install is, compliant and up to DOH standards. So in exchange for that, State Park has offered the tenant a 10-year lease extension. They have about 4 years left on their current lease. We plan to do an appraisal based on the character of use during the time period of the existing lease, and look at what an actual monthly would be based on a camp operating in that capacity. And we based the 10 on, I have a letter from Robert Garassi, who I believe is the attorney that is working with Camp Halikoa on this. It's July 30th, 2020. And in that letter, they say that they're requesting essentially a 15-year extension, roughly till December 31st, 2035. So we based the 10 on that request, which with about the 4 years left on the current disposition, that gets us roughly to that ballpark of 15. But now we're in the situation where they are looking at a 30. We haven't issued any leases for any type of park disposition. The longest one I've worked on is 25-year term for HEIA for the full management of the park. And we're not adverse to the 30-year term, but the one thing is it seems to be predicated on a $300,000 cost and amortization of paying off that loan on the IWS. Previously, in previous correspondence, Camp Halikoa has indicated there's donors that have been available to underwrite the cost of these. So I'm a little confused on whether there's an actual now economic necessity to secure the loan, or if they're just checking to make sure that if the donor is unavailable, and Camp Halikoa guys can confirm, in that regard, if it's going to be a donated cost that they get, or if they're actually going to have to secure a loan, and then look at that amortization cost over the span of say 25 30 years. And you guys have their testimony that has some rough estimates on that. So that's basically where we're at this point. And I see Rick is there, so I'm sure they're very eager to participate. But do you have any questions?
I do, Kurt. What was the fine? Well, what was a fine assessed? What was a fine amount?
Oh, I'm so sorry. I can get that to you. It was less than the 300K for us. And what happened was our AG did a really good job. Rather than have 3 separate fines, 2 state parks, 1 land division, we bundled the fine package as a conglomerate, and it reduced the overall fines rather than have them be individual. But I'm sorry, I don't have that figure offhand. Staff is listening in, so they might be able to, produce that. But
Yeah, I'd like to know.
Okay, absolutely.
But I'll listen to the applicant.
Okay.
Any other questions of state parks at this stage? Board members? Okay, with that, if none, let's go ahead, Mr. Bunshu.
I have the answer real quick, and sorry, Rick, sorry to interrupt you. The share for the Camp Holly Cove was 79,604, roughly, over the overall fine.
Thank you.
You're welcome.
Well, first of all, I just want to say that we're really thankful that you guys entrusted our organization. We're just a bunch of volunteers. I'm a pastor. Joe here is on the board too. He owns a lumber business. We have construction workers, and the state has allowed us to just gather volunteers from all over Kauai to help rebuild this camp that was basically of no use, to one that I get bugged virtually every day. When's the camp open? When's the camp open? From people all around the island, groups, and from Girl Scout groups to sporting groups to church groups. So I want to say, first of all, thank you, and we'd really like to get it back open, and because we've invested most of our money into rehabilitating the camp. You've seen our P&Ls. I gave you guys all a copy of those, so you can sort of see where we've been putting our money. We still have some cabins that are derelict, and we need to get those done. But we were caught by surprise a little bit on the whole septic system thing, and we had some donors that were willing to help us with that, but it was contingent on a longer term lease, and so they sort of stepped away, saying, well, this is taking a long time, so we don't know whether those donors are still available to even help down the road. And so we had to basically, we're going to do this and get it open. The only option we have right now is to find somebody who would loan us the money. And we were really surprised by the $300,000 price tag. But then the guys at, Sousa, who made the thing, goes, well, it is Coquet, and everything in Coquet costs more to do. We did have, just so you know, we did have drawings made up that were Department of Health regulations for that septic system, and I probably should have submitted those. They were done by Larry Dill, who actually is an engineer working with the state on the state highways, and he drew up the drawings for that, for the leach fields and all the rest of that stuff. So what we're trying to figure out is if we can get a longer lease so that we can either attract donors back to us, because on a 10-year lease, they all backed away. But if we can't, if we can borrow the money and based on what we know as our history of use, be able to recoup that in order to make payments. So that's what we're hoping for. And the worst case scenario is we have no donors and we got to figure out, pay it back, which, as you can look at the numbers, a 30-year lease seems like the only thing that we could really pull off. But if we can couple that with some donors, we could cut the time off of the lease. Joe, this is Joe. You might have something to add to that too.
Thank you guys for meeting with us. I'm also working as a treasurer, so I'm going to be the numbers guy here. So basically the numbers, if anybody wants to look at our P&Ls, we couldn't afford a 10-year lease on the loan factor strictly. If we didn't have any donations, we would not be able to make the payments. So on a 30-year lease, it works, and pretty much simply it works out to be about $24,000 a year on a 30-year lease. And with the income, of course, we're assuming that people are going to come back after COVID. We think we can make those numbers work. And then we're hoping for donations on top of that to help it so that we have a little bit of a cushion. In a nonprofit, you really you don't have any deep pockets to go to. So you really need to build up a reserve. And we don't have a reserve right now. It's been eaten up because we've been closed down for so long. We still have electricity bills. We still have to pay $2,000 a year insurance that the state is requiring us to keep on the land, even though we can't use it. And we're not even allowed to be there. So we have these costs that are going out that are basically will be out of reserve money this year. That's kind of where we're going at. We also, by getting the donations to help, there's still many more things that we'd like to see. Some of the cabins still need to be finished. And if we had a 30-year lease, we would be able to finish those cabins too and not have to force all of our donation money to be paying for the septic system. That's part of my thinking. And then the last thing I wanted to simply say is we do have choices. We're not here to say we have to have a 30-year lease. The other option would be maybe a 20-year lease, but at the current rate that we're paying, if it was guaranteed for the entire lease of $500 a year, we could make that work. But as Kurt said, he wants to set it on market value, which we don't even know what that number is. I'm estimating that it's about $5,000 a year. And so basically that difference in having to pay that extra money when the lease comes up is the difference there. So hopefully, if you guys have any questions on numbers, that's what I'm here for.
I have a question.
Mr. Oy.
So you would be able to work it with a 20-year lease plus an extra. You have 5 years left on the lease, so it would come up to 25 years.
Right. We'd be willing to go with a 20-year on top of our current lease, but it would need to be at the $500 a year that we're currently paying for that entire 20 years. Then I know from an economic standpoint, I can make that work because I know that that works into my loan program, and I know with the donations coming in, and I can also go out to some donors in the past and present that to them to help us get through that first. I think the first 5 years are going to be the toughest.
I would say this, I mean, I know our board would want to work with the state if something happened and we were able to pay that thing off real fast. We'd want to communicate to you guys so that there might be a possibility we could, up our rent to our lease amount to pay to the state if we were out of the woods on those big expenses.
Can I ask, what's your nonprofit purpose?
Yeah, our nonprofit purpose is to provide a group camping site at an affordable rate for the people of Kauai.
That's your IR. You're a 501c3.
Yes.
And that's your IRS designated purpose.
Right.
And is your camp available to any group that wants to?
Any group.
Any group.
Had everything from gay weddings to churches. So.
And is do you use any revenues from the camp for any purpose other than maintaining the camp?
No, nobody's paid. Everything rolls right back in. And by the way, virtually all the labor, almost all the labor is volunteer, unless we can't find somebody with that skill set.
I have a question.
Yeah, go ahead.
So then what you just said about if you make enough money to pay off the loan earlier, so you would be willing to pay the state off more in rent.
Yeah, I mean, that would be fair. I think what we're paying right now is fair for the amount of work we're having to put in it. But once we get that done, then I would be more than happy to say, give a
so you would be willing to Kurt is listening to go with say 5 year rental reopener, like
5 year what?
So in 2025 or 5 years from now, the state will look at how much you collecting and how much rent you're making, and if you're doing real good, then they can up your rent at the time.
Yeah, and I think we'd be fine. I mean, the weird thing about donations is you never know when they're going to come in. We take people up to the camp, even visitors from the mainland. Sometimes we show them the camp, and next thing you know, we get a $5,000 donation towards what we're doing. The Cook Foundation gave us a $10,000 donation, and we're writing grants and doing that kind of stuff, but it's all a crapshoot. So some years we might get a lot, some years we get very little. But I would certainly want to be in communication with you guys and go, hey, we've got the money, we've to be able to pay this thing off in a hurry, and then we're good to. I would think, right, it'd be good to renegotiate what we're paying for lease.
Yeah, if we have the 20-year lease and it's set to market value once the system is paid off, then I got no issues with that. That's really if we had a 30-year lease, then of course you can set it to market value immediately. But if we have a 20-year lease, then we can set it to market value once we have enough money to justify that. Does that make sense?
Okay, got it. Thank you.
Chair, I have what I think is a good workable solution that's in line with this conversation. The current disposition, which has about 4 years plus some change on it, is at nominal. So that's the 480 or the under 500. Then we're going to do an appraisal. We realize that 4 years from now, the appraisal may be a little stale, but we feel it's necessary to at least find a baseline of what this value is. And then because we're asking for then the extension upon the completion of the current term, by then these guys may have covered all of their improvements. They got the IWSs are all good, and they've been either get donors or the loan is helping pay it off. And then it just really gets to how long do we do that extension? Do we go 10, 20, or 30? But that would be then based on the new appraised rent. So that gives Camp Harlico about 4 years on the nominal, which is a pretty good comfort margin, I think, for you guys. Yeah, Rick, for 4 years on the nominal rent.
Yeah, I think so. Again, if we have a long-term lease, like a 20-year lease, for example, that's what I really need to get people to donate. And so we can mess around with the rent cost in 4 or 5 years, because by then when they see that, okay, you guys aren't going to have this ripped out from underneath you, we're not going to donate the money and it's just going to go away. It makes this a lot easier to approach people, and I think within 4 or 5 years we would probably have that funded if I can bang the drum loud enough. Again, you don't know what's going to go on in the economy, but it gives us a good shot at it, at least.
I wouldn't say we're going to get it fully funded in 4 to 5 years, but we'll have a much better idea of what we can afford to pay.
Right.
But I think I can't go to donors and ask them to invest, $50,000, $20,000, $100,000 if they don't know that it's not going to go to some other party. Because if the lease ends in 4 years and we've spent all this money and the state can just go, all right, we're going to go find somebody else that's willing to pay. Let's just come up with a number, say it's $10,000 a year, and we can't afford that, but somebody else does, but we just put $300,000 into investment into it. It doesn't make sense. No donor would want to invest into that. They need to know that they're investing into us and they believe in what we're doing for the community. And unless they know for sure that we're going to be that party that's going to be around for the next 20 years. And by the way, we're just asking for a 20-year lease. We don't plan on going anywhere for 50 years. We just know that you can only do so many year leases until you see that we're a great tenant for your state lands.
Okay.
Hey, Kurt, I got a question for you.
Yes, Board Member Gomes.
Question is, at this time, do you have anyone else interested in this besides the applicant that we have now, or Harlico? Do you have anyone interested?
No one has come forward and contacted us for this particular park unit. I assume that, if we put it out as an RFP or an IFP, that would probably generate interest. But what's interesting is we're now just starting to recover from the pandemic, and these guys are in the same situation that the rest of us are, is in terms of what our economic recovery rate will be. So I would have to hazard a guess that until the recovery rate has been stabilized, we probably wouldn't get a lot of takers at this time, but that's pure speculation on my part.
Appreciate it. Thank you.
Other questions, board members?
Kurt, Tommy. So Kurt, you'd be willing to, instead of a 10-year extension to a 20-year extension, then rent a reopener maybe every 5 years?
Yeah, I think that's a good, solution. Like I said, 4 years from now, we'll have a new base rent appraisal. We'll see where they're at, and then we would then either tack on 10 or 20. I'm comfortable with 20. I was uncomfortable with 30 just because of the precedent, going that long on a camp, operation thing. So 20, I think, is a fair kind of in between, based on what they're looking at with their amortization schedule, and us just having, kind of more standardized terms for our dispositions.
Okay, thank you.
Any others? All right, there's no other public testimony on this. Somebody want to make a motion on E1?
Can make a motion. I'd like to make a motion on E1, amending the extension to 20 years with 5-year rent to reopen, every 5-year rent to reopen thereafter.
Second.
Thank you. I think this is assumed, but can we add with the condition that it remain in its current use available to the public to rent for camp purposes?
Okay, I'll be willing to add that.
Thank you. Mr. Gomes, you okay with that?
Yes, and a new septic tank.
3.
3. Yeah.
All right. We have a motion to approve the submittal as amended with a second. Any further discussion? If not, all in favor, say aye.
Aye.
All right, that passes unanimously with 7 board members. All right, thank you very much. Thank you for your work on this, and good luck.
Thank you. Thank you. Really appreciate it. We're stoked.
Okay, we're gonna switch out and move to F1 through 3. We're going to hold off on F4 until a little bit later in the meeting. So let me just pull some different staff in here.
Sorry, Chair, which F item did you?
We're gonna do F1 through 3 now, and we'll hold off for a little bit on F4. Did I get that right? I think I got that right. Yep.
Okay, ready for us?
Yes, please go ahead. I think we have everybody here.
Right. Thank you, Chair, members of the board. Brian Nielsen, Administrator of Division of Aquatic Resources. Item F1 is a request for approval to enter into a federally funded memorandum of agreement of $104,000 for goods and services between the Department of Health and the Department of Land and Natural Resources to support the mission of the state's polluted runoff control program. I've also got our program manager, Ryan O'Connell, here, who's the subject expert, can answer any questions. Thank you.
Thank you. Okay, questions, board members? Hearing none. We have signed up, we have Laura Jackson, but I don't think she's here. Okay, and there's no other public testimony, so is there a motion to approve F1 as submitted.
So moved.
Second.
All in favor? Aye.
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 Okay, that passes unanimously.
Okay, thank you. F2, I'm going to hand it over to our aquatic biologist, Kathy Goecki.
Hi, Chair Case and members of the board. My name is Kathy Gawicki. I'm an aquatic biologist with Division of Aquatic Resources. And today I will be presenting F2 for item F2 for DAR. F2 is a request for authorization and approval to issue a Papahanaumokuakea Marine National Monument Conservation and Management Permit to Dr. Michelle Barbieri Lino, Pacific Islands Fisheries Science Center, for access to state waters to conduct Hawaiian monk seal management and recovery activities, inclusive of the removal of individual sharks at French Frigate shoals, displaying predatory behavior towards monk seal pups. And this permit is a renewal. The monk seal program has conducted operations up in the monument for many years and has received a permit since 2008. The program consists of conservation research activities aimed towards understanding the biology, ecology, survival, and recovery of the Hawaiian monk seal, including but not limited to population monitoring through tagging, photography, aerial surveys, and acoustic recording devices, and recovery interventions such as disentanglement of monk seals from marine debris, administering of antibiotics and vaccinations, rehabilitation or translocation, shark predation mitigation activities, and removal of marine debris itself. These activities will be conducted at all the islands up in the monument, including Pearl and Hermes Atoll. And so the monk seal team based at Pearl and Hermes Atoll will follow the current draft BMPs for mitigating the potential spread of the algae Chondria tumelosa, and will be disinfecting all their gear and the small boat at the end of the season before returning to the main Hawaiian Islands. And due to COVID, the monk seal program was not able to conduct activities in the monument last year. So this will be the first time they're going up since 2 years ago. The permittee and the lead scientist for the Hawaiian monk seal research program, Dr. Michelle Barbieri Lino, is here today to answer any questions that you may have.
I have a question. Although I realized that over the last year, because of COVID, there wasn't any activity along these lines. In the previous year, even though you have a target of 20 sharks, I also recall that in previous years, the number of actual take was much lower than that. Can you report, just briefly summarize what the most recent years efforts were?
I'd be happy to. Hi, everyone. I'm Michelle Barbieri Lino, and thank you very much for the opportunity to be here today and answer your question. So since the beginning of the project, there have been 7 sharks removed in total out of that initial request of 20. Last year, no sharks were removed because we did not have our field team present to do so. And as you acknowledge, the catch per unit effort is generally quite low. So most of the time, we're removing 0 to 1 sharks per year.
Mm-hmm.
Any other questions?
I have one.
Mr.
A prior permit that we approved was they were going after the Galapagos sharks or something because they were predators to the Hawaiian monk seal. Is that considered one of these that is going to be affected too?
That is correct. We're specifically targeting Galapagos sharks and only Galapagos sharks that are found exhibiting predatory behavior towards Hawaiian monk seal pups at Lalo. And our fishing is specifically in the shallow lagoons around the islets where that predatory behavior is occurring. Initially, when this problem was identified, there were folks that were going out in terms of ecosystem modeling experts as well as shark biologists. And our team was helping in terms of identifying the individual sharks that were thought to be engaging in this behavior or observed, whether they had tags or distinctive markings on their dorsal fins. And so it is specifically in those areas with those individual sharks, and that's what we're really targeting in these efforts. The effect on monk seals is more on the order of 25% of the pup cohort every year. So it's a very small number of sharks that are thought to be doing this, but it has pretty devastating impacts on the pups born at Lalo.
Thank you.
Mr. Oy?
Chairman Case, you know that the legislature passed a law regarding sharks. Would this shark taking affect the law, the shark taking?
Dark can offer answers, but it's I think special activity permits allow take.
Because I wouldn't want to do something that
Right.
something that was going to be against the law that they passed this year.
Right.
Yeah, I believe, all shark capture is already prohibited in the monument without a special activity permit. So I don't think the current or the law that the governor just signed in would affect this. But the new shark law also does have provisions for special activity permits. So shark research can still continue under special activity permit in the main Hawaiian Islands as well.
Okay. Because I know that under the law, DNR was responsible to come up with rules. Yeah. So.
Yeah, good point. We still have to come up with the rules for the harvest permit, but I don't believe we need to develop rules to begin issuing special activity permits for shark harvest once the bill is effective, I believe January 1st of 2022. David Sakota can correct me if I'm wrong on that.
That's correct.
Okay, thank you.
Any other questions? If not, is there, Mr. Yoon, are you about to ask a question? No. Is there a motion to approve F2?
So moved, Chair.
Second.
All in favor, say aye.
Aye.
Aye, that passes unanimously. Okay, thank you very much.
Thank you very much, Chair and members of the board.
All right, F3.
Okay, F3, our program manager, David Sakota, will introduce this item. I believe all the members of the public wanting to testify are present on the Zoom. David, can you confirm?
Yeah, I think so.
Yes, students who signed up are in the meeting, yeah.
Okay, thanks. Take it away, David.
All right, thank you. David Sakota, Fisheries Program Manager for DAR. F3 is a request for final approval to amend and compile Chapter 13-34 Hawaii Administrative Rules to update rules regulating the Pupukea Marine Life Conservation District. The primary purpose of the proposed action is to amend the boundaries to include the Kapo'o tide pools within the MLCD to further protect those resources. That's been the intent for a while, as evidenced by the transfers of that area to the state. And so this rulemaking action will just finalize that. We held a public hearing via Zoom on January 19th and received all supporting testimony. There's no testimony in opposition. And I believe some of those who provided the supporting testimony are in this meeting as well. But I'm happy to answer any questions. Again, this is mostly a housekeeping item to strengthen the protections for resources in that area.
Questions, board members? If not, let's go to public testimony. Let's see, first Denise Antolini, welcome.
Aloha, welcome to everyone to the tide pools, which are right behind me in the virtual picture. So I'm going to transport you up here to Kapo'o. My name is Denise Antolini. I'm the volunteer president of Malama Pupukea Waimea, testifying on item F3. We just want to express our gratitude to the board. We were in front of the board about almost a year ago in August for your approval to go to public hearing. As Mr. Sakota said, the public hearing was unanimously in support. I would note that that support came from residents, from scientists, including Alan Friedlander, Cindy Hunter, and Whitney Goodell with National Geographic Pristine Seas and University of Hawaii, as well as Keiki, who enjoy the area. One thing about this virtual photo I wanted to point out is the water clarity post-COVID. It was absolutely stunning. And we really need to protect this area, which is a refuge for the entire MLCD. We have a lot of juvenile fish, a lot of really interesting critters, benthic, and it's subject to all the stresses that you can imagine. So this little 3 acres is quite important. So while the rules package is indeed housekeeping to align it with the executive order, it's incredibly important to the marine life and to our efforts up here to steward the area. Let me close with our gratitude to DAR, to Administrator Nielsen, David Sakota, and a large team that helped get this package moving, and also to DoCare. We are a Mackay Watch partner for DoCare. We really value that relationship and all the support we get from DLNR for helping our efforts to protect this area. So mahalo for your support. We appreciate the board's continuing support for marine reserves, effective enforcement, and community partnerships. Mahalo and aloha.
Thank you. And Ms. Yagodich.
Aloha. Aloha board members and Chair Case. My name is Jenny Yagodich, and I am the Director of Educational Programs and the Mackay Watch Coordinator for Malama Pupukea Waimea. And we're the community nonprofit, like Ms. Antolini said, that cares for, educates about, and protects the Pupukea Marine Life Conservation District. I'm here in strong support of Division of Aquatic Resources efforts to amend and compile Chapter 13-34 of the Hawaii Administrative Rules, including the inclusion of the Kapo'o Tide Pool area into the existing Pupukea Marine Life Conservation District, so that the rules and regulations protecting the area can be enforced. So like Denise said, we mahalo you for supporting this process, and I'm here to answer any questions you might have. Mahalo nui.
Thank you very much, and thank you for all your work on this. Any questions, board members?
I don't have a question, but I do have a comment. Thank you both to volunteer president Antolini, and also to the coordinator Jenny Yagodich for being here and testifying. It really is heartening to me whenever I see strong community support and involvement in the management of our marine resources. And so I just wanted to mention that, and thank you both.
Any other questions, comments, board members?
Yeah, I do, Chair. Hi, Ms. Antolini, and thank you for your backdrop, and I appreciate you mentioning the water clarity. You know, the same thing kind of happened statewide with the absence or limit of people and human beings. What are your guys' thoughts going forward to that regard?
Thank you, Member Yoon, for that question. In fact, I didn't mention, just because I wanted to keep my testimony short, that we are also collaborating with DAR on the first ever management plan for the MLCD, and as part of the state's 30 by 30 initiative, which is, is quite broad, but we have been very fortunate to have been early participant in the management plan process, and now we've had regular meetings with their 30 by 30 team. So that is maintaining that water quality, the pristine nature, it's AA waters, of course, is a key part of our management plan efforts. So yeah, very much top of the mind. I should just mention in closing that this Kapo'o tide pools in particular get heavy use. And even right now, I mean, even though the foreign visitors haven't arrived yet, the use is tremendous. The other day, I think we easily saw 120 people in the tide pools in this little area, and they're not aware that they're trampling someone's home, right, or habitat. So along with Jenny's educational efforts and our work with Mackay Watch and some additional signage, education programs, we have a lot of work to do, but completely in agreement with what you said. We need to maintain this. This is an example of what we can do. Yeah, mahalo.
Thank you. Any others? If not, is there a motion to approve?
So moved, happily.
as submitted. Second, all in favor, say aye.
Aye.
That passes unanimously. All right, thank you very much. Nice to have this critical step finally done.
Absolutely.
Aloha.
Mahalo nui.
Okay, we'll be moving to K1. Okay, K1, Sam Lemo, when you're ready. Okay, I guess while he gets ready, we'll move to the M items. So we'll let in the M items. Okay.
I apologize, Chair. I was
Just in the nick of time.
I was talking and my mute was on. I saw you just staring and I thought, God, I'm not talking to you now.
Okay, let's go ahead with K1. And we had Mr. DuPont from I think from DAGS waiting, but he was not able to stay. So go ahead.
Okay, just give me 1 second. All right. This is hopefully chairperson, board members, is always a pleasure to serve for you guys. This should be fairly straightforward. Essentially, what we're looking at here is an after the fact conservation district use application for a public purpose subdivision. It's up in the Kokei area of island of Kauai. The applicant is the Department of Accounting and General Services on behalf of the Office of Enterprise Technology Services. Tiger's the staff planner. We really went into this and tried to figure it out. It was a little bit complicated, probably because of lack of good record keeping, not necessarily on our part, but just that and Hurricane Uniki. In any case, it was a telecommunications site established in the 1960s by the U.S. Air Force. The U.S. Air Force allowed the county of Kauai to put a radio repeater station at the site. This is started in the late 1960s and on in the 70s. We had Hurricane Uniki, the site was destroyed. And of course, this is all subject to a general lease from the state of Hawaii. We come in later. For some reason, DAGS takes control of the site. There is a partition of land maybe in the early 90s that the department never was a party to. And so it's come up recently, I suppose, because they were asking for some improvements to the site from us recently. We noticed that the site was not ever properly subdivided by the board. And so effectively they're seeking an after the fact subdivision today so that they can, I suppose, correct the mistakes that occurred in the past. And there is one issue that Deputy AG Melissa Goldman brought up with respect to our reference to Chapter 343 HRS, indicating that we did not cite the correct exemption. And she provided language, which I did forward to you, Chair, regarding what that proper language might look like for this particular situation. And I don't, unfortunately, I don't have that language in front of me as I'm speaking, but I sent it to you via an email earlier today.
I'm sorry. I think you sent me a note about it, but I'm not sure I got the language. Let me double check.
I can try to find it here and read it. But I wholeheartedly agree with Melissa Goldman's recommended amendment.
Okay, wait.
There she is.
If I might jump in, Chair, this is just a correction to the staff submittal on page 3, paragraph 3. It's non-substantive. It's just to update to the November 2020 exemption list rather than the 2015 list. And specifically, it amends the submittal by identifying general exemption type 1, part 1, item number 41. And that's really all that's necessary on the record today.
Okay, yeah, I do have that here
Okay.
in your email, sir.
Okay. So with that, thank you very much, Melissa, Chair. We're recommending that you approve this after the fact public purpose subdivision for DAGs.
All right, any questions, board members? No questions? No public testimony. Mr. Oy, would you like to, I guess I shouldn't assume, make a motion to approve K1?
Make a motion to approve with the amended wording to chapter, what's that? 243.
Okay.
Second.
All right. All in favor, say aye. Aye.
Aye.
Any opposed? Thank you. Passes unanimously. Have a great weekend.
Mahalo.
All right. We are moving to the M items. First is M1 through 12. We have Ms. LaRue here. These are all revocable permits. I'm going to ask if there are any questions on M1 through 12. Hearing none. Do I hear a motion to approve M1 through 12 as submitted?
1 to 12.
Second.
Recommendation.
All right, I'll take that as gone. Motion and Gomes second. All in
Or
favor?
the reverse, actually.
Reverse.
Reverse, okay.
Yeah.
All in favor, say aye.
Aye.
That passes unanimously. Thank you, Ms. LaRue. Have a good weekend. Okay. So now we have Mr. Karn for M13.
Yeah, Derek Karn, DOT Harbors, here to answer any questions on M13.
Okay, board members, any questions on M13? If not, there's no public testimony. Is there a motion to approve M13?
Move to approve.
Second.
All in favor, say aye.
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 That passes unanimously. Thank you.
Okay, thank you.
And last, on the M14, Ms. Tomita.
Hello, Jennifer Tomita, Property Manager with DOT Harbors, here to answer any questions you have on M13.
Any questions, board members? Mr. Char, you're on mute.
With reference to M14, I'm confused on the month-to-month permit and a lease. Why are we month-to-month, or are we on a extension of the lease?
So it's basically to update their month-to-month permit while we work on a lease. So the ultimate goal would be to get to a 35-year lease.
So the action taken today is just a month-to-month permit?
Yes, with requests to directly negotiate with them for the lease.
So at the time of the lease, will that come back to the board again? Or are you asking us to authorize a 35-year lease also?
Do you know the terms of the lease yet, or is that
No.
still under discussion? All right,
No.
I think it's a good question, Mr. Chair, and I think we should just do the month-to-month permits now and have you come back when you're ready on the lease.
Okay.
Okay, thank you. Yeah, Mr. Chair.
Well, with that clarification, I move to approve staff approval with the understanding that at the time the lease is to be extended, that it comes back to the board.
Okay, so we'll take that as an amendment to delete the issuance of the lease portion and just to issue the 4 month-to-month permits.
May I,
Yeah.
excuse me, sorry, this is Deputy AG Melissa Goldman. Just the staff member mentioned requesting permission to enter into direct negotiations for the lease. Is that something that the board would take out or leave in?
So is this a situation where direct negotiation is appropriate? If so, I don't think we have to authorize that. Do you agree? And Ms. Tomita, do you agree? Or do you think you need board authorization to negotiate a direct lease?
I agree, as and I'm gonna come back to the board anyway when we get the lease.
Okay. We good? All right. All right, is there a second?
Second.
All in favor, say aye. Aye. That passes unanimously. Okay, thank you very much.
Thank you.
All right, and then last on the M items is Ms. Pham. And we have written testimony that was received on this, M15.
Yeah, Leah Pham, property manager. I'm just here to answer any questions if you have them.
Okay, any questions, board members?
It's just there was a lot of support for this M15. So that's all I wanted to say. It was great.
There a motion to approve M15 as
So
submitted?
moved.
Second.
All in favor?
Aye.
Aye.
Passes unanimously. Okay, thank you very much. Have a great weekend.
Wow.
All right, that leaves us with
F4.
Ms. Goldman, are we able to go ahead with it now?
I think so, Chair Case. Thank you for delaying. We were just giving some time for another deputy to possibly join us, but given how efficient this meeting has been, I think we can go ahead. I can contact him if we need his counsel.
Okay, and I do know we have some written testimony received on this item. So Dar, please go ahead with F4. F4.
I believe there was one member of the public that was wanting to provide oral testimony, Eric Kingma.
Yeah, he sent in written testimony, but he has not signed up for oral testimony, and he's not in the waiting room.
Okay, I thought that Darlene had sent him the link, but I guess he'll.
Darlene, have you heard from him?
I sent him the link this morning, but I don't see him in the waiting room.
Okay.
Okay, so I guess we can proceed and
Yeah.
DAR program manager David Sakota will take the lead on this one.
Okay, good morning again. F4 is a request for final approval to amend and compile HER 13-74 to increase the commercial marine license fee for non-residents of Hawaii from $100 to $250 per year, and to make some other non-substantive clarifications to the rule chapter. Yeah, I think we've explained to the board before the rationale for increasing the non-resident fees. We subsidize the management of non-resident commercial fishers who generally don't pay state taxes, state income taxes. And the amount we laid out in the previous submittal before we went to public hearing was about 500,000 for DAR management and about 850,000 for DOCARE enforcement for non-resident commercial fishing, for total commercial fishing. The non-resident pro rata share was about 240,000 per year of subsidy. And so this increase of $150 per non-resident, averaging about 800 non-resident licenses issued a year, would be expected to generate about 120,000 additional, which is roughly half of what we could raise it to considering the subsidy they're getting. So that's the justification for it. We did hold public hearings in January, or a Zoom public hearing. We didn't get anyone show up to the hearing, but we did receive written testimony in opposition from Dr. Kingma with the Hawaii Longline Association. We've attached the letter to our submittal, and we've also attached a response that we sent. And I think the board has an additional written testimony for this board meeting where HLA has stated that we haven't justified the increase and claims that we don't manage the longline fishery. But I just want to address that, to let the board know how we do manage the fishery. Basically, we're required by law to issue commercial marine licenses to anyone that lands fish in the state, whether they're fishing in state waters or not. So even though the longline vessels are fishing outside of state waters, we issue licenses to them. And the process of verifying these applications and entering them into our system takes significant staff time. We have to check their passports, their I-95 forms. So I talked with staff this morning, and they spend approximately 2 hours per vessel. And one vessel generally has 5 to 6 applications associated with it. So there's 140 vessels that have to renew each year. So 2 hours per vessel just to review the applications and input them into our system if all the information is correct. It's not uncommon for expired passports or missing information or wrong names. So that adds significant staff time when staff have to follow up with that. And on top of that, they also need to print out the license cards and do the mail out. So it does take significant staff time and resources to do that. In addition, we manage the longline fishery through our participation on the Western Pacific Regional Fishery Management Council. That's not mentioned in the letter, but Westpac does make management decisions and recommendations to NOAA. NOAA actually does the rules, but the state of Hawaii sits on that council. For the past few years, I've sat in the Hawaii seat for chair case. So that does take a significant amount of time also and effort. Last year, we also distributed $2.5 million in Hawaii CARES Act funds to longline fishery participants. I spent a considerable amount of time on calls with stakeholders, including Dr. Kingma and other longline representatives, as well as developing the spend plan so longline vessel owners could get paid from that. So to say we don't manage the longline fishery is just simply not true. Maybe not to the extent that NOAA does, but we very much co-manage this fishery. I also talked with DOCARE, and they also enforce longline vessels. They go down to Honolulu Harbor and check the longline vessel crew for their CMLs. So there is enforcement, not as significant, but we do enforce the longline fishery. But all that to say, this rulemaking, this fee increase is not targeted toward the longline foreign crew. It's targeted towards non-residents in general. We have no control over whether the longline vessels employ non-resident or resident crew. If they have an issue with the fees, they could employ residents on their crew. Although I think for other reasons it's cost prohibitive. We're not saying that they're absolutely free riders and the longline fishery doesn't contribute anything to the state. We're just saying that these crew members, I don't think pay state income taxes. I could be wrong, but even if they did, they'd be lower than, say, if they were residents being paid minimum wage, which would contribute more towards, what goes towards fisheries management. So in the end, they're subsidized by our state taxes, and we want to increase those fees. I guess the last consideration is the legal consideration. And the courts have held that the state doesn't need to calculate the precise amount. We just need to generally have a rational basis for why we're charging a higher fee for non-residents. And, I think we've provided significant justification for that. So if there's any questions, I'm happy to answer.
Chair, if I could just add one other comment. Just so the board is aware, the state legislature also just passed into law authorizing the Department of Land and Natural Resources to issue vessel licenses. So this would be a license that covers the vessel rather than requiring every crew member to obtain a commercial marine license. This isn't in effect yet. We still have to go through rulemaking, but DLNR is authorized to move forward with a vessel license, and we expect in the next year that would provide another option for fishing vessels that don't want to license each individual crew member. They could opt into the vessel license option if they were interested in that. So just wanted to add that for your awareness. Thank you.
Thank you very much. Thank you both for that very good detail. Any questions, board members?
Just for clarification and my curiosity, I'm sure that Hawaii is not the only one that has differential fees for non-resident versus resident fishing. And did you folks have a chance to compare the rates among different states that do so? And is ours comparable or lower or higher?
Yes, we did compare. I'm sorry, I don't have the numbers, but in general, we're very comparable to what other states are charging the differential.
Okay, in other words, this new rate is comparable to what other states are charging.
Yes, that's correct.
Okay.
Other questions?
David. Yep. David, how long has it been at $100?
I think it's been since 2016.
Okay. All right. Thank you.
Other questions? Mr. Ewan?
I hope this is quick, but the longliners raise a legal issue, and I want to make a motion to go into executive session to consult with the board's attorneys on questions relating to the board's powers, duties, privileges and immunities, and liabilities.
Second.
All in favor? Aye.
Aye.
That passes unanimously. We'll go into executive session.
As soon as the names
Wait. Mr. Kingman just entered the waiting room. So I think we will hear his testimony before we go into executive session. Darlene, can you please reverse that, and we'll let Mr. Kingman in here. Kingman. 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5, 6, 7. Okay, just checking, Mr. Oya, are you here? Yeah. Okay. Mr. Kingma, we would like to have your testimony.
Sure. Yeah. Thanks, Aloha, board members. Sorry, I thought the meeting was tomorrow, but I think it was Kamehameha Day, right? And this is on international call. So thanks for letting me join. I'll try and tell my children to keep it down in the background. I'm doing double duty here. So I assume you guys already just heard the proposal by HSTAR, and thank you for allowing me to provide these comments and testimony. So I'm the executive director of HLA. We represent, the fleet as well as the associated seafood industry, and we're opposed to the fee increase in principle, just because we don't think that HSTAR has provided the analysis associated with the Ninth Circuit decision to the Hawaii Longline fleet. And in our testimony that was submitted, we identified 2 areas. And the first area is management of our fishery, which is principally by the federal government. And so I think in the California case, as they view the fishery, it's non-residents that are participating in California managed fisheries. And so in our case, the fleet doesn't fish in state waters. It fishes outside of 75 nautical miles in the EEZ, but about 90% of our fleet's effort is in the high seas. And all of the fishery management regulations that pertain to the fleet are federally derived, as well as enforcement by the U.S. Coast Guard and NOAA Office of Law Enforcement. And then secondly, the California case identifies non-residents that are benefiting from state management as free riders because they're not paying taxes. They come from out of state, whereas in our case, the CML holders that are non-resident in our fishery, those that are paying for those licenses are all paid by local Hawaii residents. The fleet, the vessels are owned by local Hawaii residents. So our vessel ownership are not free riders. And this is because the use of foreign crew, vessel owners pay for everything, room and board, food, medical, as well as their license fees. So in that sense, our fleet shouldn't be considered a free rider because our local ownership is paying taxes and paying quite a bit and contributing quite a bit into the local economy. So those are our comments. We don't think they've been really addressed in the response that we received from HSTAR. We'd appreciate if they could take the case of our fishery and really take a hard look at the rationale used in the California case and apply it to our fleet. And if it did show that it's different, then we would be happy to pay this increase if there's a difference there, but we don't think it's really been applied. So that's the essence of our comments. If you guys have any questions, happy to take those. So thank you.
Okay, questions?
Chair,
Mr.
Chair,
Glanzer.
I think that Mr. Kingman has to know that he can, whatever the decision is that because he wasn't here, he can do a contested case too. He can apply for a contested case, whatever our decision becomes after this matter.
Yeah, I'm not sure.
I actually believe that contested cases aren't available in rulemaking.
Okay. All right.
And I think that's in part due to the public process that the rules go through prior to coming back
thank
here.
you.
No problem.
Can I just add one more comment about the management of the fishery?
Yep.
Thanks. And by no means it's taken as a slight towards HSTAR in any way. We know that HDR has its hands full with managing the state's coastal resources and as additional, core reef ecosystems, et cetera. So by highlighting that the fishery is managed federally, by no means did I mean to imply that the state has any, is not concerned with our fleet, but in terms of actual management regulations, they just don't apply. So I do know that HDR does have its hands full with managing the rest of the state's coastal resources. Thanks.
Yeah, and I'm not sure you were able to be listening in when David Sakota was testifying, but he did go through quite a detailed list of all of the efforts that the staff needs to take every year to manage this fleet under Hawaii law. So although he did say, although NOAA primarily manages the federal fishery, there is a very significant nexus to Hawaii management with Division of Aquatic Resources that takes actually quite a bit of time. So you may have missed that testimony.
Yeah, sorry, and thanks, Chair. David, maybe if we could connect offline after this, and you and I could go through that list, because I'd be interested to see that. Thanks.
Okay, any other questions?
Yeah, one more for Mr. Kingman, just out of curiosity. And I understand what you just said, and I acknowledge that. So do you oppose the $100 fee?
No, we don't oppose the continued status quo of $100 at all.
Okay, but you understand its necessity. It's just the increase that you oppose, right?
Right, and we wouldn't be opposed to necessarily an increase as long as it's tied to the rationale involved in the California case, that decision. So
okay,
yeah. And I'll just note the recent, I guess, enactment of the vessel CML bill may make this issue, I don't know if it's called moot in the future, but it may change the status for our fleet in terms of non-resident CML. So as we shift to a vessel CML and we encourage HDR to quickly develop those regulations, this issue may go away, and we'd be happy to sit down with HDR and the board to identify what level of vessel CML fee would be appropriate for our fleet.
Okay, any other questions? All right, we had a vote to go into executive session, so we will go ahead and go into executive session now with the board only
Thanks, everyone. Follow.
and our AGs. All right, we are back in session. And board members, do you have any further questions or comments on this matter? Okay, does somebody want to make a motion on F4?
Move to approve per staff's recommendation.
Is there a second? Mr. Oy, I'll give it to Mr. Oy. All in favor, say aye.
All right.
That passes unanimously. All right, thank you, staff. Thank you, everyone, for your work on this. AGs. Thank you,
Thank
board
you.
members, for all of your work. And everyone have a great long weekend.
Yes.
Same to all of you. Aloha.
Everybody.
Uh,
Hoi ho.